Okay, hi everybody. Thank you for having me here. So what I'm going to do is I'm going to give kind of my standard stump speech about generative AI and copyright, but I'm going to give it more rapidly than I normally do because I know that you are more familiar with the issues than my normal audience. So a lot of this is based upon joint work with these two, Catherine Lee and A. Peter Cooper, uh, computer scientists, PhD students at Cornell, also do lots of other things. And so we wrote this long paper that is half technical overview for the legal people and half legal overview for both the legal and technical people. There are a lot of copyright lawsuits against generative AI companies, and though there are a lot of individual variations in the claims they raise, the companies they're suing, and the specifics of how they frame their claims, they all start from this take that obviously there are copies involved. If you start with the basic provisions of the copyright law, copyright protects original works of authorship fixed in any tangible medium of expression. Well, original work of authorship is such a low threshold that it covers all kinds of things: blog posts and tweets, photographs and digital images, web text, all kinds of material that is used as training. And the fixation requirement is almost autologically satisfied for anything that's in a condition to train an AI. If nothing else, the process of training itself creates copies that the Copyright Act can reach, which means almost everything that is made by a human that is ingested by an AI training process is copyrightable by someone. And once you have that, the copyright owner's rights include the right to reproduce the copyrighted work, to make copies of it. Well, those copies are all over the training and deployment process. Those copies are present in large-scale data sets that training starts from. Those copies are present in the storage, potentially in a model itself or in memory during a training run. And those copies are present in the outputs generated by an AI model. And so you might have cases in which the AI, when prompted appropriately, outputs something that is a clear, close copy of a training work. We have here outputs from Midjourney and DALL-E that clearly resemble Banksy's Girl with Balloon. Those models have learned enough about that original work to generate outputs that would be infringingly similar copies if they were produced by a human artist. We also have harder questions in which AIs learn to imitate the style of particular artists. So on the left, we have illustrations by Holly Mengert, and on the right, we have outputs from an AI that has been trained specifically on her style. And it's a hard doctrinal question whether those outputs copy enough from any particular work to count as infringing copies of it. But it's clear that the AI is doing something based upon the copyrightable expression in her works. So basically, there are copies everywhere, all of which are potentially infringing. And this is the point at which AI developers and users bring in the fair use defense. And in their view, the fair use law is sufficient to shield them from liability to the point that almost everything they do is not infringing. So fair use, which I should point out is unique to United States copyright law and is not a feature of other copyright systems around the world, is this general purpose standard for excusing what would otherwise be infringing uses of a copyrightable work. And in addition to some illustrative examples like criticism, comment, and teaching, there are 4 factors that any court considering it has to balance, including, most importantly, the purpose and character of the use. How is it actually being used by the defendant? And also the effect on the market for the work by the plaintiff. There are 2 strands of fair use case law that seem to come together around generative AI in a way that makes a very good case for AI developers and users. One of them is what's known as transformative fair use, the idea that the expression in a work is modified and put to some different purpose. This is from a case called Keynes versus Scotty Nation. The guy on the left is a mayor who seems like a character out of an 80s movie because he hates fun and partying in the town. He tries to go after a block party that happens every year. People associated with the block party create these t-shirts of him in order to make fun of him. He acquires the copyright in the photograph and sues them. The court holds this is a fair use. They have modified the expression in the photograph and put it to a different purpose. And that transformation in the expression and it's what it's being used for make this a fair use. This is your classic retail level fair use, an individual work tailored and modified in a way that changes what it's doing. But there are also wholesale fair uses. We call them bulk technological uses. And one classic there is plagiarism detection. So there's a case called Turnitin.paradigms, got Turnitin. Student term papers are used to detect whether other term papers crib from them. And so here you have the outputs of this system, which is telling you whether or not they are similarities. Some students who don't like this being done to them, they kind of, it's a privacy violation, sue, and they use copyright as their tool. The court says this is a fair use, that it's effectively not for an expressive purpose. People aren't using the plagiarism detection software in order to enjoy reading these essays as a substitute for buying those essays. They're using it to make sure the students actually wrote the papers themselves. This is essentially a technological aid that's not competing with or usurping the copyright owner's interest in capturing expressive audiences. The most famous example of this kind of a bulk technological use is the Google Books case. Google scans millions of books and makes digital copies. And among the things it does with them is create a search engine for books. You can find which books mention a term. It creates the Ngram viewer, which lets you track the usage of a term over time. One of the things the court points to is that these are not really expressive uses. You don't go to Ngram to have a exciting aesthetic experience. You use it to learn about the books rather than experiencing them directly. So this leads to a general principle that a number of copyright scholars have pointed out, which is that bulk technological uses that only consume the works for their non-expressive features, that don't result in humans reading the books to enjoy them, tend to be fair use. So you can put generative AI at the intersection of these two trends. The outputs frequently defended as transformative fair uses. You're putting together source works in a way that combines them and remixes them and shuffles up their expression, makes them that looks different. And the training data and the training process is non-expressive fair use, that you would build this data set, and yeah, but nobody's going to come and crawl in order to experience those blog posts. It's being used almost exclusively to train AIs. So the models themselves, to the extent that they implicate the copyright system, maybe under both of these. They transform the expression into new forms, but they also involve things that are only meant as an input to a computer process. The problem with this is that it's quite plausible that some outputs do actually infringe. That you can actually get out works from a generative AI that are substantially similar to one of the inputs. They're not transformative automatically just because they came through the AI system. And if the outputs are expressive enough to be visible by a human, the non-expressive argument might not go through. So at this point, having made this rejoinder, the next compromise people usually go to is to argue that the answer isn't always yes or always no, but sometimes, and the sometimes are precisely when a user prompts it in a way that causes an infringing output. So that users are the ones who are, in some sense, at fault for or responsible for infringing outputs. The leading case here is the Sony case involving the VCR. Sony sells VCRs, people use them to tape copyrighted shows off of the TV. the Supreme Court says that even if those uses infringe, Sony is not liable because it sold a device that was capable of non-infringing uses, taping Mr. Rogers to watch it later with your kids with his permission, time shift. And so people making generative AI systems want to say, we're making a device that's somewhat like Sony, and we shouldn't be liable for the infringing uses because it also has non-infringing uses. There's a factual issue with this one, which is that the VCR doesn't come with a library of video programs that are copyrighted built in, whereas arguably that's what a excuse me, that sneeze was a long time coming. So arguably there is an entire library of copyrighted works built into the model, and the Sony paradigm of secondary liability doesn't really account for the works that are bundled into the model itself. Those copies are made by the companies and institutions that train them. But another more recent example showing that the system can in fact impose some liability based upon the involvement of the system with its users is Napster. The file sharing litigation is all about companies that didn't directly touch the copyrighted works themselves, but instead created a system that could enable users to exchange them. Applying secondary liability doctrines, the court in the Napster case and the court in similar cases said, yes, but you have ongoing control over the system and you're profiting from users' infringement, or you have the ability to prevent the infringement and you have made a material contribution to it. The courts would say, you have to prevent user infringement of specific works when you have enough knowledge to do that. That you have an ongoing control, and therefore you need to take action to prevent infringement. That is similar in some sense to the way in which an AI company deploying an AI as a service has ongoing control. And then you lay over that the fact that you have the DMCA safe harbor for user uploads. YouTube uses this. YouTube is not responsible for copyright infringements in videos uploaded by users unless it receives a takedown notice from the copyright owner and fails to take action. So all of this leads to suggestions that we should have something like the YouTube DMCA secondary liability notice and takedown system. But making the tool by itself is not infringement, but once a infringing generation has been pointed out to whoever's providing the service, they need to take sufficient actions to prevent it from being generated in the future, a kind of takedown process. This has some doctrinal and practical obstacles. The doctrinal problem is it's not at all clear that the Copyright Act authorizes some system like this. The DMCA takedown process is statutory. Congress enacted it to deal specifically with hosts like YouTube, and this typical garden variety AI generative system doesn't fit within the definition. This doesn't apply to them directly. But even if you're going to try to rewrite the law to put something like this in, it raises practical problems for both copyright owners and AI companies. Copyright owners can't easily search all of the outputs of a system where they can search all of the videos available on YouTube. So it would take some kind of immense user surveillance to find examples of their work in the first place. And also, with YouTube, YouTube can very much specifically disable a particular URL and disable access to a particular video on its site. The typical AI system is much more of a black box. We have much less understanding of exactly where in the model the work that's being emulated exists. So it's much harder to engage in targeted unlearning. And this is an active area of research. I think it's fair to say we do not have the same quality of off-the-shelf disabling unlearning that we have for straight-up file storage. So what I want to suggest, and this is in some ways the point of our article, is that trying to ask, does generative AI infringe copyright, is asking the wrong question, because you are not going to get a good yes or no answer. It simply depends upon too much. And to make the case for why this is fact-specific, I want to point out that copyright is always inherently highly fact-specific. So take these two images. This is a teaching example I use with my IP survey class. On the left, you have a photograph of a hula dancer. On the right, you have a stained glass image of a hula dancer. And if you're just asking, are these things similar? I think you would probably come to an answer that yes, they are, very quickly. Indeed, it quickly becomes apparent that the stained glass has to have been based upon the photograph. The artist used it as a reference in order to lay out the images. But that's not the end of the matter, because while the shapes are similar, there are lots of things that are different. The color of the stained glass, the texture of the glass, the details have been flattened out, the volcano in the background has been added, other details have been erased. And then you have to say, wait a minute, some of the features of this are not original to the photographer. The pose is traditional. It's not something invented afresh by the photographer. The lays are not original to the photographer. Those are traditional in dance too. Other features are original but not copied. At the end of the day, the court concludes that there is not an infringement here. The portions that have been copied that were original are small enough that they don't amount to infringement. And I think that's a correct and easily defensible conclusion. My point is that copyright law always depends upon this level of close engagement with source and target works in order to make infringement judgments. And so if we're going to talk about AI memorization, we're going to have to make similar judgments. Here is a fairly famous example of image model memorization. I think it's actually a really hard question whether we would count this lossy memorization as sufficiently similar to infringe. You need to remember that there's no copyright in what anagram lots looks like. And you need to ask how many of the details of the photographer's choice are present in the output image. It's not obvious to me that this is infringing. It's not obvious that it's not infringing. You'd have to go and do a close analysis of it. Similarly, you're going to have hard questions about when an output copies not closely from one specific work, but from an entire style or from a genre. This is one of the examples in our paper. We prompted Midjourney with adventurous archaeologists. We get out a bunch of images. And it turns out they all look kind of like a certain character played by Harrison Ford in a bunch of movies. And there are things like the brown and white colors of his clothing, the whip, the belt going across his chest. None of those are inherently implied by adventurous archaeologists. Those are all features of the Indiana Jones character as depicted in a bunch of movies. Now, does this mean that these images infringe? Again, it's going to require a fairly close factual analysis and some policy decisions about copyright. I can easily tweak the example. Imagine the model being more detailed or less detailed, and you can easily see that Gen AI models could be more or less infringing depending upon their details. At one extreme, you're going to have just a very simple classifier that tells you some very basic facts about a work. Something that comes much closer to the engram viewer than to say it actually does original generation. At the other extreme, you could have a model that is so overfitted on the Indiana Jones movies that if you prompt it with one frame from any of the movies, it will immediately reconstruct the entire rest of the movie frame by frame for you. Those are both theoretically possible, and I think there's an line of infringement somewhere in between the two of them. The other thing we point out in our paper is that you can't talk about Gen AI and infringement without zooming out from the model. We might want to focus on a specific generation or think of the model by itself as the only possible source of infringement. But in fact, as you well know, the training and deployment process involves a large number of steps, which can be done in a large number of ways. At every stage, from creating the content and curating the data sets to deploying, fine-tuning, and aligning the outputs, you have lots of choices that quite plausibly shape whether something should be regarded as infringing or not. So just to point out some of the ways in which the supply chain can be complicated, any given artifact could draw on multiple upstream sources. There's not a one-to-one data set to model mapping, and even a deployed system may have multiple models in it. At the same time, you can branch out in the other direction. Data set can be used to train lots of different models. Models could be used in lots of different systems. Foundation models are fine-tuned before being deployed in many different ways. Each of those can affect your judgments about infringement. And there are many ways to do each stage. You could release them publicly, or you could keep them held privately. You could apply a license that lets people use them, versus you could apply a license that very restricts what they can do with them. You could group these all under one company's umbrella, or do them by different parties, which can affect the nature of who's liable for what. The point is just that there are lots of combinations, and there is no reason to think they all have to have the same legal answer. So let me pull back a bit and talk about some different ways that the system, with a copyright system, could deal with these problems. So here are 5 futures that could come out of the current infringement litigation. One pair of possibilities are if the plaintiffs start winning these cases. So far they haven't, but it's still early on enough in the process that a few judges could push an outcome in which the copyright owners win. If that results, well, I gotta say that it's not clear what future is going to hold. One possibility is that the plaintiffs win. You need permission from copyright owners to train on in-copyright data, and it turns out you need big enough data sets that the way to get one is to negotiate with a large-scale copyright owner, the New York Times, the Getty Images, Sony Music. And they are able to extract very large royalties from AI companies for training. Basically, they wind up pocketing all the money there is to be pocketed from doing this. But maybe it's possible that even their data sets aren't enough. Maybe you need to train on the web as a whole. Well, if you need to do that, and you need to get a license from everyone, and that's just impossible at the scale of the web. You cannot negotiate with everyone who's ever written a blog post or posted a photo. If that is the case, then you pretty much need to negotiate licenses you can't get, which means that you are not going to be able to train really high quality models. We've created a future in which copyright law prevents a lot of AI progress. Okay, that's one branch. The other major branch people point to is maybe the AI companies win. Maybe the copyright plaintiffs lose all these lawsuits. Well, again, what happens depends on what you think the future of the tech and business here is. Certainly one possibility is that big tech wins, that the companies that are currently leading with their very large models develop a dominant position. Nobody can compete with OpenAI and Google, and you just have a few titans with the resources to train huge models and develop cutting-edge results. Maybe that's the future, maybe not. It's looking increasingly like no. People with much more limited resources can still train pretty good models. And maybe they're not quite at the level of the cutting-edge GPT that OpenAI has, but they're very good. They're great for most purposes. They're small enough to deploy on local devices. And in that world, you have a huge proliferation of models, almost to the point they become unregulable for any purpose. Maybe we don't get either of those futures. Maybe neither side gets definitive wins. We have some lawsuits that go some way and this way, and we start to get some guidance that you can do this, but not when training AIs. And copyright law does what it's almost always done and produces some guidance that some people can live with and others can't, and leaves us in a state of uncertainty for years. If I had to bet, I think we're probably on track 5, but I don't know. The other thing I want to point out here is that I've only been talking about one half of the picture. I've been talking about the infringement side. But the other half of the big copyright questions we're going to have to answer are, what about the copyrightability of things produced using AI? The leading example here would be Zarya of the Dawn, comic book, graphic novel produced by Chris Castanova. Copyright Office grants the registration and then takes it back once they find out that Castanova used Midjourney to make the illustrations. We're going to have a dispute over whether the human authorship requirements can be interpreted really strictly or not. And that's wide open. And what I want to put to you is that the infringement question and the copyrightability question may be setting us up for the biggest transformation in copyright history. If you think back to the last time we had a technology that might have been this revolutionary for publishing, it would be the printing press. Before that, you have a system based upon patronage and sponsorship because the cost of creating a work is high and the cost of copying is high. Only if you have the money to make copies is it worth doing anything, and you get your money because you're paid by either you have the money yourself or somebody pays you to make it. What the printing press does by driving down the cost of copying is first make it possible to have a business model selling copies to the public. I will write this once with a lot of effort, and then I will print hundreds of copies and sell them to people and recover my costs by selling copies. So it creates a new business model. And it also creates the possibility for others to undermine your business model by running off pirate editions. They get a copy of your book, they retypeset it, they print their own. Copyright law, a century and a half after the printing press, forbids that practice. It allows the author to be the one who sells their copy for money, prevents others from doing the same. Well, the printing press drove the cost of copying down substantially. Generative AI has the possibility to drive the cost of original creation down in a similarly dramatic way. Computers have certainly helped with creative production. People can create music and video on a scale they could not have before by themselves. But the degree to which generative AI can be used as an aid to creativity may mean to a similarly dramatic reduction in the cost of creating anything. And in a world where anybody can create like that, it's not at all obvious that incentives to create of the sort that copyright offers are the appropriate system of law to govern this new information. It may be that what replaces copyright due to generative AI is as different from copyright as copyright was from the patronage system that came before. So that's what I have for my prepared remarks. And I would really be delighted to have a conversation with all of you about whatever interests you.
Yeah, thank you so much for walking us through that. I think maybe I'll start with one question, give people a chance to kind of gather their thoughts, and they can chime in as well with any questions they have. As I already told you, I have several, but I don't want to monopolize the time. It seems like your presentation kind of concludes in the beginning that the inputs, making the copies and stuff, that's most likely that's going to be fine. It's the outputs where the focus should be. Is that correct?
That was the view offered by AI companies. That's probably, it's broadly right in its approach, but I have some critiques of it. Basically, the argument goes, we can see that the outputs are infringing, and while the inputs might be literal copies of existing works, they're being used as inputs into a process that is mostly non-infringing, so fair use ought to forgive them. I think that argument gets weaker and weaker the more that outputs infringe. If one output in every 10 million is infringing, that argument is very strong. If one in every 10 is infringing, it looks a lot weaker.
Yeah. That sounds good. Does anybody else have any questions?
I'm sure I will in a few minutes, but I'm mulling them over. So please, David, your questions are very good at leading these discussions.
Yeah, okay. So earlier when we first got on, and part of the reason I talk about the inputs is this idea of the robots.txt, and everybody here understands what that is. Do you think that it has, and in your paper you mentioned that books 3, for example, may not be, I think you even said it's likely not fair use. training on with material like that. So does the provenance of the data matter, do you think, on whether an outcome is like a transformative use is going to be fair use?
This is a really hard problem. I think there are good arguments that some uses of the Books 3 corpus are not fair use. Like certainly the entire corpuses that power pirate libraries are probably not fair use when they're being used in that way. It's not completely obvious to me that that infects the rest of the system. I can see the arguments for and against. There's another classic fair use case, Harper and Row versus The Nation, where The Nation magazine gets its hands on a purloined copy of Gerald Ford's memoir a week before it gets published. And they rush out a story with the most interesting things from the memoir, which are actually not that interesting because Ford's really boring. But they get that story out, and Time magazine cancels its cover story excerpt of material from the book because it's been scooped. That's a case where not only is the competition between the two of them significant, but the Supreme Court calls out the fact that they got this manuscript through basically theft by somebody working in the publishing business. Somebody takes a copy and smuggled it out. You've got authority for the proposition that a tainted source can hurt the fair use case. At the same time, because of this multi-factor balancing test, it's quite plausible that it's not a per se rule. Maybe there are cases where, yeah, some of the material in the training set was acquired illicitly, violation of terms of service or some other obligation, but it's a small part of the whole. We're not going to condemn the whole thing just because a little bit of it has this questionable origin.
And does the quality matter? So, for example, Books 3 would not be a large portion of the corpus, but maybe the books are the higher quality, like the more they're coveted because they're edited in their longer form and so forth. Would that weigh in, or is it strictly just like the amount?
That's a great point. That idea of attributing the value of something to different sources comes up in several places in copyright law. One of them is that when we talk about how much of a work has been copied, we make a distinction between ordinary parts of the work and the heart of the work, phrase from the Ford case. And when you're copying the heart, the thing that makes it valuable, that's more likely to lead to liability. I would think that a similar principle would apply when the reason that your derivative work is most valuable is precisely because of this one input, even though you used a lot of other stuff to make it. And you use a similar reasoning in copyright remedies. When you've been found liable for infringement, the court will ask how much of your profits were attributable to the infringement when they're awarding damages to the plaintiff.
And this is a similar question I've been toying around with my mind is, a chatbot is not usually the primary thing that makes it useful is not that how it chats, that it's coherent. It's what it chats. It provides some use to you, which you can only gain from like the underlying ideas and stuff. And clearly that's not copyrightable. Mm-hmm. But that shows you that that's like that's like the value of the material you're copying. It's like, to me, they're kind of intertwined. Like you wouldn't do the scraping just for the expressive parts of it. You'd want that kind of underlying ideas and stuff, which is what makes it valuable to sell to anybody else. Like it's the way anybody creates writes the document in the first place.
Yeah, that's a great point. There are a bunch of cases that I call them extraction cases, where somebody's made a copy of something in order to get at non-expressive information in it. So one thread of these is publication of laws. There are companies that publish state laws, and they publish them as compilations where a lot of the components are the thing the state enacted as its laws, and the rest of it is commentary or annotations provided by this private publisher. Well, there's a right to copy the laws. That's not copyrightable in the first place. It's an edict of the government. So a number of courts have been very sympathetic to plaintiffs who copied the form provided by the publisher, because it was the official version of the laws. And so basically, if the only way you can get at the uncopyrighted meat is to bite through this copyrighted shell, well, I guess you just have to. And so there's an argument sometimes that if the only way or the best way to get at the facts is by making a bunch of copies, yeah, then you can go ahead and make those copies. It gets harder if you are republishing the surrounding material. But yeah, I think that's the non-expressive use argument is very receptive to this kind of extraction if you have to make copies in order to get at the uncopyrightable stuff. Of course, there's a hard conceptual line to draw between what's idea and what's expression, but in principle, yeah, you can have a pretty good argument for pulling out that information.
Okay. Yes, I'll pass off to Sydney here. I can't hear you.
It doesn't say you're muted, so it might be on the wrong microphone or something.
Your hand gestures are on point, though.
Yeah. Yeah.
I guess while she's doing that, so do you think that something like Common Crawl would be at risk of a copyright infringement claim? Like you mentioned, like they're not collected in a manner that's for enjoyment, but it is a copy, and a copy is a copy is a copy, kind of that argument. Do you think that would apply to them or any other kind of data sets?
I'm surprised.
Okay, me too. I didn't know if I was like an oddball here, if I missed something.
Yeah, I think part of the story here, and this is absolutely talking here in a more private setting, is there are two kinds of lawyers bringing these lawsuits. There are the well-compensated, very sharp firms hired by Getty and the New York Times who have their clients' commercial interests at heart. And the New York Times knows it needs, they want to strike a deal with OpenAI and Microsoft. They don't care about Common Crawl, and they are not going to get any leverage by pressuring them. And then you have the plaintiffs' lawyers who are filing these class actions who are honestly not as good and miss interesting or potentially good legal theories. And they're also just suing the defendants you have heard of who appear to have money. It's not like these litigation campaigns are being strategically waged in order to hit every point where the copying could be stopped.
Yeah. No, that makes sense. Sydney, you're ready to rock? Yeah.
Oh, nope.
No.
I can't hear you. Was it your birthday recently? Is that a balloon for? Oh, no.
Okay, sounds good. How likely do you think is that, like, at least with how copyright law currently is set up, that something like Books 3 or something that's like kind of egregiously just stolen works, like a big collection of parody books or something, how likely it is you think that like a company may be forced to like destroy a model that contains some especially poisoned data set, at least in the short term? Because that I think is sort of an existential question to a lot of organizations, but I'm not sure where the line will end up there.
So this data illusion remedy is something that a number of other scholars have been starting to think about. Elizabeth Joe is the first one who really pointed this out, to my knowledge, then Pam Samuelson has been writing about it. I think it's a very serious risk. If you think that a model is a copy of the input works, and I think there's a very strong case under the Copyright Act that it is, if you think that and then you find infringement, it follows that destruction of the model or prevention of use, any further copying of the model, which is equivalent to destruction because you couldn't use it anymore, it's very plausible that's a remedy for infringement. Now, it might be that courts would find that they're not going to go that far and they'll just award damages, and the damages will be compensating you for the value of the model. But it depends on how motivated the judge is to reach that outcome. Tim Lee and I discussed this a bit in a post on his blog, Understanding AI. And it comes down to the realpolitik of how much you think judges are willing to pull that trigger.
Sure.
Yeah, I call this like the Uber issue. There's there's a paper called Regulatory Entrepreneurship. I think it was published at Yale, and it's like this idea that the companies, if they get so ingrained, it makes it harder to eradicate, and therefore like a judge is less likely to pull the trigger on something like that. But
Yeah.
real quick, before we go to Sydney, I wanted to pick up on this idea you mentioned that you think there's a good argument that a model is a copy of the data. Do you mean a derivative, or do you actually mean a copy? And I'm just kind of curious what the theory is behind that.
So there's a huge confusion / debate in copyright law as to where copy leaves off and where derivative starts. My personal theory is that, in fact, the two categories overlap really substantially. And what the derivative work right does is show that even a change in format could still be a copy within the meaning of copyright law the owner can control. So I would tend to say that there's not a consequential difference between the two. It's going to be a derivative simply because the model includes something else. It can change. So it is a derivative work within the meaning of Section 103. Whether it's also a reproduction or not is kind of a distinction without a difference.
That is interesting. That's an interesting way to look at that too. Yeah, thank you. Sydney, you're back.
Yeah, let me try this. Is this
Hey.
working? Okay, amazing. Sorry about that. So yeah, I was really curious about this kind of insight that you had at the end, which is that copyright law was developed at a certain time to guard against certain kinds of violations and have incentives towards certain sorts of structures, and that the landscape that we're living in now is just very different. So like the function of that law has in many ways like completely changed. So I'm just wondering if you have a thought about what sort of new law might be created that like adjudicates the space that we're living in now. What sorts of incentive structures do we want to have in place? What sorts of things do we want to be restricted and so on?
It's a really hard question. I've started trying to think about it, and I don't have clear answers. The instinct or the vibes that I'm chasing after is my sense that both AI creation is really exciting and is letting people create things of real value to themselves and each other that are both interesting and useful in old ways, but also really exciting and doing things we've never seen before. Combining that sense of excitement with a real sense of uneasy horror at what AI-driven spam is doing to every site on the internet open to contributions, competing with journalism, flooding spam detectors, overwhelming search engines, all of that seems bad. So I'm trying to think towards what would be a good system that gives us more of the former and less of the latter. And I don't know what law can do about it yet. It might not be that a copyright style exclusive rights system is the thing we need. We might need regulations that preserve spaces of authenticity, that allow people to defend themselves from AI creativity and competition when it's not appropriate to the regime, while otherwise leaving people to use these tools pretty freely. But that's very speculative. I don't have a sense of it. I feel like I should talk to some economists. I should talk to people who study artistic communities, talk to journalists, but I have no idea where that will go.
Do you think copyright owners, when they share something on the public internet, still retain like a right to exclude like another type of property right? Like, so go back to like robots.txt or terms of service, things like that. So I know there's one camp that believes like once it's on public internet and anybody can just like access it without an account, then you kind of lose control over it, right? You retain your copyright, but you don't have a right to exclude. Do you think that's fair?
So people want to make all kinds of arguments about what you do or don't retain when you put something on the internet. I certainly see people who have the instinct that if you put it on the internet, it's now public and free for anyone to do anything with. That's not right legally, but people have that sense. I also have the people express the belief that they can put something on the internet, put whatever conditions they want on it, and you have to respect those conditions. You can only read this if you get up and turn around 3 times before you start reading. That's not right either. it's fundamentally a policy question whether we want to allow people to retain certain levels of control after they have posted something publicly. We could impose those restrictions through copyright and control the information. We could impose them through trespass to chattels and the Computer Fraud and Abuse Act and put it as restrictions on scraping. But fundamentally, it's a question of a policy question. How much does the legal system want you to allow to say, you can generally do this except for X, Y, and Z? We've had this weird system for about 2 decades in which you could use robots.txt to say, you can look at this or you cannot look at this, but it had no language for expressing finer grained restrictions. I feel like with the rise of AI opt-out flags, we're starting to get some actual pressure in terms of the uses that are and aren't allowed.
Yeah, that was kind of something I was thinking about last year, is this idea that the current regime of robots.txt is a little bit coercive. It's like, be discoverable, but allow everything to be scraped or be invisible. And you can maybe prevent people from scraping you. So I think the fine tuning would be helpful.
Yeah.
Does anybody else have any questions? I don't want to be like trampling over anybody. Crystal, did you have any questions? I don't know if you're still around there.
No, I think the things that I was wondering have been covered by the various questions. But I guess one piece too would be, with the current fair use test, it is a very sort of case by case application. But if we were to, I guess, amend the factors, or do you feel like the factors should be amended, specific for AI, specific for developers or end use? How would you, I guess, ideally apply the fair use test, and how would you amend it?
So I would be actually pretty happy with recognizing in the fair use test certain patterns of uses that are always fair use. This is sort of what some authors like Pam Samuelson and Mike Madison have written about. That there are some fact patterns, if you fit into them, you almost always win your fair use case. And so a bunch of the parodies fit into this paradigm, where if you make a parody that clearly actually has parody component, you are going to win. So I would be pretty happy with a regime in which we did something like that as fair use or a statutory safe harbor for training, and actually pushed all of the liability into secondary liability. If you make a model, you have done nothing wrong, and it's going to be on you to prevent infringing outputs from being generated. And if somebody does generate them, we ask, how much did you know about it? How much could you control those outputs? And try to answer those questions more at generation time than we do currently. It's just that I think that the notice and takedown regime is a bad way of doing that, and that I don't want to take the models off the table completely under current law, because I don't think they are.
Great, thank you.
I have a question related to from the user of the language model, or like the generative model perspective. Like, presuming that I say, hey, I am to say generate an image of an archaeologist, and it just coincidentally happened to be similar to Indiana Jones, right? But and I decided to use that, and there is an argument whether it's fair use or is it just like infringe on copyright. But if it is an infringe on copyright, then who is the one responsible? Because the prompt that you provide to the model is something very generic. It's just the model choice to do. There is an argument that, oh, well, you can actually act as a filter if you say, hey, it looks like something that might be copyright, you could get into trouble. But what if the person doesn't know? Like, let's say they haven't watched the movie, they have never heard of it before. Who's gonna get sued?
Yeah, it's another good one. We had a piece about this in the paper, because this is what's called the volitional infringement issue in copyright law. And so I couldn't present 150 pages here, but we have a several page excerpt that talks about this specific problem. basically, you can distinguish a case in which the user is trying to get an infringing output out of a model that is not specialized for infringement. So like I'm asking for like, X scene from Indiana Jones from a general purpose image model. That's really on me and not the model.
Mhm.
But you can also imagine the case you just described, where I give it a very generic prompt, not even knowing who this guy is, and the model gives me Indiana Jones. There's also a case where it seems like the model developers and I are in cahoots to infringe. Right, I type in complete video of Indiana Jones and the Raiders of the Lost Ark, and the model starts giving me the entire movie. Because it was trained to just infringe, and I'm taking knowing advantage of that fact. So I don't think we can have a categorical rule that it's always on the user or always on the model. There might be different factual cases where one or the other is the one who's most responsible for the fact that the output is infringing.
Mhm. Got it.
Are you surprised? Oh, sorry, go ahead.
Mhm.
Yeah, and so another thing, there's these famous, Gary Marcus, he's kind of, the famous critic, and he posts these ones where an Italian plumber, right? And Mario pops up. It still like pops up on Dolly even after all these months, where like presumably Microsoft and OpenAI know better, but it's still showing up in their designer, and that scares us here. We're avoiding doing image generation for this reason, that apparently it's more difficult to eradicate than you would think, or at least $1 trillion company hasn't figured it out yet.
I don't know if this is one of Gary Marcus's examples, but one of the ones I love best is a robot who is not C3PO will give you C3PO.
Yeah.
And like, it's really hard to know. I mean, if I'm asking for an Italian plumber, maybe I'm genuinely, honestly asking for something other than Mario. Maybe I'm just asking for Mario without using that word, like I'm trying to get around a word filter on the system I'm using. One of these things I've learned from thinking about legal questions is it's extremely hard to know for certain what something means without knowing the context. That is, somebody can say, like, I agree to your contract and we have a deal, when in fact it could be 100% obvious from surrounding circumstances that you and I both know the entire thing is a joke. And you always need more evidence, or there's always potentially more evidence that could make your tentative conclusion wrong.
Yeah. It's true. It's also like feels so unsatisfying that there's no clear answer.
One more thing about that is, I was doing some reading about corporate law, and one of the things that sort of stunned me is there is literally nothing you can do to be 100% guaranteed certain that the leader signed with the company is in fact legal and authorized by the company. You can make the company show you like a certificate signed by somebody who claims to be the full board of directors that this person is their agent and is authorized to act on behalf of the corporation. But that document could still be a forgery. Like there's like nothing you can do to drive that down to 0%. It's always going to be 0.0001.
Yeah, I guess that's why we're always going to be employed as lawyers. I'll pass off the pal here to kind of wrap it up. Looks like we're at the end of the hour, but happy to have you kind of.
Oh, I'm not sure whether we can do this in time. I have another case, which is like presuming that you have a language. So like instead of 2 parties, you have 3 parties. So you have the language model provider, you have a company that is building a product that use the language model, and you have the end user that use the product. Let's assume that the product is, say, a website that show people book summaries. And now, for some time, coincidentally, without the intention of the company that used the model to do, like they have the prompt that is a template that the user can say activate and say, when the user go to the website to a web page specific to that particular book, it shows summary of the book, and sometimes it show like sometimes summary include exact copy of the text that appears in a certain part of the book. Then is there any infringements going on over here? And then who is the responsible? Because the user also have an option to say, I want to look at this particular book when they figure out like, oh, I can read part of the books by using this website, right?
So to be sure that I have this right, you have a general language model, and then somebody's fine-tuned this to pull up individual books and a user who's using it to do that?
No, it's more like the model, like sort of like something, yeah, I would say something similar to that. Like you can visit so there is a company that is building a product that using the language model as a backend, and maybe they have
And then the
access
language
to the
model
book
emits text of the book, and so the company
and
building
create a
the product
summary.
doesn't, yeah. And so the user is just like, I want this product to do it, but the company that actually provided the ability to query the model to the user is not the one who built the model, and doesn't
Like
have a lot of
sometimes we would do
introspection
word
into
by
it.
word reproduce. Yeah, sometimes we would do word by word reproduction.
Yeah, so this is one of these places where I feel like it's not so much that there is a off-the-shelf answer I can pull to, as that a copyright lawyer's approach to this is, well, at least I know how to set up the problem. Like a physicist is saying, well, at least I know how to draw the force diagram, and I can start going from there and try to solve the equations. And the way I would do this is I would say, okay, there is a copy of this book being produced, and the user asked for this, and they made a request of the system. First thing I do is, who is responsible for that final act of infringement? Is it the user who entered the prompt, or is it the company providing the system that emitted this text? On the example you gave, it seems more like the user is the one who is proximately connected to getting this specific query. The user would be potentially the primary infringer. That could be very unfair to them if they had no idea this would result, but they made this copy. At that point, we would then ask, is the provider of the system to the user secondarily liable for it? Did they know it would produce this output? Probably not, so there's no contributory liability. Did they have the ability to control the infringement? Yes, but they may or may not have profited from it. There might or might not be vicarious liability. If that company is liable, they would then potentially seek contribution from the creator of the language model they used, and whether they could or not would be determined by the contract. So the two of them would allocate the risk of copyright infringement, and that would be a standard thing they would address in their contract to use the model or not. And so you see in some cases things like the companies offering their users copyright defense pledges, where if you use our model within these parameters, we will protect you and pay any copyright judgments that are assessed against you.
I see.
Fantastic. Thank you so much. I really enjoyed this. I appreciate you taking the time to talk with us.
Yeah, this is great. Thank you.
It's really exciting. I rarely get the chance to talk to an audience that is not a bunch of law professors who are this up on the issues.
Feel free to call more often.
Yeah.